Tonight's meeting to order. It is January 4th, 2024 at 6 p.m. So first of all, quick introduction. My name is Carl Granrath. I'm the hearing examiner for tonight's hearing, which is going to be a little bit different than how we do things typically for hearings. And I'm going to go over some of that now, as well as I believe Mr. Callahan for the county is going to cover some of that as well after I give a short introduction here. Like I said, I'm the hearing examiner. The purpose of tonight's hearing is for me to gather testimony and evidence on the matter that's pending. That is an appeal of some county decisions. I will make a recommendation based on the record that is completed tonight and all the evidence that I've already reviewed and any other evidence that may be submitted tonight. Again, along with the testimony, within 2 weeks, I'll make a recommendation, submit it to county staff, and then it'll go to the county commissioners for the final decision. So, as I said, the kind of order of operations here is set up in county code, but also gives me some discretion to move some stuff around as I see fit or as things unfold. But generally speaking, we're going to have an introduction of the appeal by county staff. And then as this is an appeal, the burden of proof is on the appellant, and so then they will basically have an opportunity to state their case in chief. And there will be an opportunity, limited opportunity for testimony or evidence in support of their appeal from members of the community. And I believe Mr. Callahan is going to speak to that. After that, the county has their opportunity for their case in chief, and then testimony or evidence in support of the county's decision. Again, under limited circumstances, we'll go over in a second. And then the final word does go to the appellant, as it is their burden of proof for this appeal. So with that, I'm going to hand it over to Mr. Callahan for an introduction of the case and some specifics that will govern our proceedings tonight.
Thank you, Mr. Granrath, and good evening, everyone. I'm David Callahan, Kootenai County Community Development Director. The one thing I would add to your opening remarks is that the public that is allowed to speak tonight must be an affected party, and that's defined by code. It's a person or entity with bona fide interest in real property which could be adversely affected by tonight's decision. Typically, thank you. Thought things didn't sound right. Thank you kindly. Typically, that would be a neighbor within some reasonable distance. There is no absolute number. That's where the discretion you brought up earlier comes into play. But in my experience, anyone that's within the neighborhood is generally an affected property owner. And you've outlined the order of procedure, so the only thing I can add until it's the county's turn to speak is to the opening issue of what this is about, which is this is really an appeal of my determination for two things. One, we believe that an RV is being improperly used, contrary to what the code allows. I'll explain that in detail when it's my turn. The other thing we believe is going on is that the property is being used as a commercial riding arena or equine training facility, or both. And we have evidence to back up that concern. But again, I'll hold off on that until it's our turn to speak. So that is what this case is about. And with that, I'll wait until it's our turn.
Thank you, Mr. Callahan. Just to add on to that real quick, when there will be opportunity for essentially public comment, although we're not going to call it that tonight, I will ask for the persons who are speaking to make a brief statement about how they are an affected party, given the definition Mr. Callahan just gave, basically stating if you're a neighbor, you live next door, something like that, that would make you an affected party. Because again, this is a normal procedure for hearings. Anyone from the public can generally come comment in one of these meetings. That's not the case tonight. So it has to be someone whose real property may be adversely affected by the outcome of tonight's proceedings. So a brief statement of that, if there will be any of people speaking. So with that, we have counsel for the appellant for their case in chief.
Yes, thank you. Thank you, sir.
You can speak there or there, it doesn't
I'd
matter.
like to stand.
Sure. Is the microphone on green? There's a little button that'll turn it green. There, that's okay.
So let me, we are here under you have it marked as case number APP23-0001. There are two violation charges at issue. So unless the hearing officer would have a preference, I would assume address both together for purposes of expedience.
Please.
And that gets me first to the notice of public hearing. There's a defect in the notice. It addresses that Appellant McGuire is also appealing the director's determination that the current use of the property meets the definition of a commercial riding arena, boarding stable, or equine training facility. That is not what the notice of violation sanctions Ms. McGuire for. That's the notice of violation is, in case ending in 177, states, quote, property owners are advising a kids riding event for 6-21-2023 without the required conditional use permit. It doesn't identify what the actual violation is other than advertising an event which is marked as Exhibit E to the materials we submitted, which is simply a flyer that says there's a kids camp which occurred off-site, had nothing to do with the actual property. So the issue is, does the ordinance allow a property owner to be sanctioned for advertising an event that doesn't occur on their property? And the answer to that is no, it does not. So we'll go to the citation for the RV issue. Now, this is fairly straightforward. On November 8th, 2022, Ms. McGuire received a citation in case number ending in 526 by Mr. Sepulveda. And the citation was for violating Ordinance 493-8.4.401, temporary or intermittent use of RVs. And this is what the charge said. Several occupies and skirted RVs in use on the property. Possible RV park in operation. A week later, the county inspector, Mr. Sepulveda, came out to the property and confirmed that there was no violation. He wrote so much in the record details we obtained from the county, marked as Exhibit C, where he says, quote, I conducted a site inspection and I was able to verify there are only 2 RVs on the property and they are only used as temporary or intermittent use, period. Skirting is not actual skirting, is more of an animal barrier, in a parenthetical, no insulation value. And he explained to Ms. McGuire when he was on site that skirting, to be skirting under the ordinance, there has to be an RV value. And the skirting, which wasn't actual skirting, that existed was just a barrier to keep out the critters from getting underneath the RV. It had no R value. That's not disputed. For some reason, which I think can be gleaned by the supporting correspondence with Mr. Sepulveda and others submitted in support of the appeal, the county dragged its feet and did not release that citation until mid-April of 2023. They released it, no violation, mea culpa, we made a mistake. Then 2 months later, it issues a citation for the exact same conduct it had previously determined was not a violation. That is the citation ending in 178. which is being appealed here today, which says, quote, property owners have a skirted RV on the property, period. RVs cannot be used as permanent residence and RV cannot be skirted. And it alleged the same statutory or ordinance violation as asserted in the prior notice of violation 526, and that being 8.4.401. Now, Ms. McGuire and a few others here today will testify that absolutely nothing changed between the time the first citation was issued and the time the second citation was issued. The property, the RV, no one was living there, and the RV was not skirted. There was no RV value to the barrier to keep out the animals. And you also have, this is more of a housekeeping, you should have, I believe, let me tally them up. You should have approximately ten or so comments in favor of appellant that were submitted, or that we know about, could be more. One of those was from William Carter, who he was actually on site last November, or November 2022, when Mr. Sepulveda came out and said, this isn't skirting. This is not a violation of the ordinance. And he put that in his comment. And again, this is William Carter, 555 North Demito Ave, Oregon, Eugene, Oregon. It's a little bit difficult to read, sir, because it falls in a dark spot of the page. But we'll call Ms. McGuire and Ms. Smith, who are going to testify that there was no skirting nor use and occupancy of that RV. Essentially nothing had changed since the first violation. So that gets us to, circling back to where I began, the citation ending in 177, which says, quote, property owners are advertising a kids riding event for 6/21/23 without the required conditional use permit. There's nothing in the code, nor could there be anything in the code, that could lawfully prevent someone from advertising an event that did not occur on their property. That's their charge. So if you look at, and I'll find it here, and it's Exhibit F, which I mentioned previously. This is somehow the county was sleuthing around, trying to find things they could use against Ms. McGuire, and they found this. And I don't even believe Ms. McGuire. Is that your property in that picture?
No.
This is a picture. It's not Ms. McGuire's property. It says there's a kids camp, kids riding camp. Call me for details. Doesn't say the location, gives the date. It's undisputed it didn't occur on the property. Mr. Sepulveda showed up that day, parked at the entrance of Ms. McGuire's property, and has personal knowledge that no such activity occurred on the property. Yet what do? They continue and prosecute the notice and the citation. So really, the only thing I could, in reading through the statute and trying to come up with what legal basis do they have for their charge. And first of all, they don't say what ordinance Ms. McGuire actually violated. They just say she needed a conditional use permit. Okay, what does that tell us? So apparently it's not allowed under the existing ordinance for her to advertise an event off-site. So I have to make some speculation here because they leave no other choice. So the speculation I've discerned is they are saying that under this code provision, 8.5.11, subpart I, which says, quote, boarding stables which are not associated with a commercial riding arena or equine training facility shall not be required to obtain a CUP. Okay. That's the language. Now, the only thing the notice of violation cites her for is this one flyer for this off-site event. So apparently the county's reading of this code is that if you are a boarding stable, there's no evidence, Your Honor, that she was operating a commercial riding arena or equine training facility. So if you're a boarding stable and you advertise an off-site event, that somehow converts you to be a commercial riding arena or an equine training facility under the ordinance. And that is a stretch. That is a stretch. And I'll point the hearing examiner's attention to Ada County v. Gibson. That's 126 Idaho 854. I mean, zoning laws they're in derogation. This is a paraphrase quote from that decision. Zoning laws are in derogation of common law rights of free ownership and use of property. So more than one reasonable interpretation is possible. The interpretation that favors the least restrictive use of the land is favored. Okay. First, it's unclear what their interpretation is. But Ms. McGuire's interpretation that this flyer promoting a kids' camp off-site when there's evidence known to the county that nothing occurred on-site that day is not prohibited under the Kootenai County Code. And the same is true for the RV statutes. The intention is to prevent people from having a second home on their property by having someone live out there permanently. That's why skirting is prohibited, because that adds R value so you can live in an RV like you could a home. It doesn't apply to something to keep out pack rats. At least it's up for reasonable debate and interpretation, and tie goes to Ms. McGuire. Her interpretation is reasonable. With that, I'd like to ask Ms. McGuire a few questions, if I may.
A few questions for you first. First of all, will you please identify yourself for the record?
Oh, yes, Nathan Oler. Sorry, counsel for Ms. McGuire.
And I will have to have you fill out one of the sign-in sheets after, so we have that written down as well. So you penned the March 8, 2023 letter to the city's civil deputy prosecuting attorney, Patrick Braden, right?
Yes, sir.
Okay, so within that letter, you identify, I think some of the issues that you raised here about perhaps maybe a code interpretation issue, but that you and or your client were pursuing a conditional use permit and in fact had submitted an application for a conditional use permit to perform some of these activities.
Well, at that time, Ms. McGuire, that was something she was in the process of doing, yes.
So to your
I
knowledge-
wasn't personally involved with that, the CUP permit.
Okay, so you actually don't know if it was filed or not, or didn't work on it at all?
I didn't work on it. It was filed, and I believe Ms. Hilbrand has followed up with Ms. McGuire. But given the fact that, after the county realized it made a mistake in issuing 2 citations previously and released them, only to turn around and cite Ms. McGuire again, one for the exact same thing, it's a cost-benefit analysis. She has not operated any, what they took issue with before was something done by a former barn manager who's no longer at her property. That's number one. But number two, all that Ms. McGuire has done, which she has done for 17 years, she has a few boarders, 6 I believe at the moment, and occasionally she would give a lesson to a kid who was boarding a horse at the property. Now, the county, and this is Mr. Sepulveda, took great issue with these care leases, which is a very common practice in the horse industry. That's where Someone wants to learn how to ride a horse. Someone wants to ride a horse. Someone wants to care for a horse. They don't own a horse. So they basically go to a barn and say, hey, I'll rent your horse. I get to go, I'll feed for it, I'll care for it, I'll ride it. So they eventually realized that that was not a violation of the ordinance and backed off that issue. But it still seems they take issue with occasionally allowing or teaching a kid how to ride a horse on Ms. McGuire's property, which I think is a great stretch under the ordinance. But Ms. McGuire can't handle these incessant charges and this just focused attention of the county. So she hasn't done any of that. She just stopped giving riding lessons. And she does everything off-site now. So one would think that would have satisfied the county. No, it doesn't. Now they're saying she can't even advertise an off-site event, and that's nowhere in the code.
All right, real quick, 1 second. So, again, going back to the CUP that may have been filed, and I'm hoping the county and perhaps your client will be able to shed some more light on this. From the record that I've seen this far, and again, your letter, the CUP was filed and conceivably could have resolved many of these issues if it had been completed. Was there? I mean, are you're familiar with the CUP process and getting a CUP?
Yes, I don't understand how it would resolve this necessary issue.
Well, I guess you're right. I should be very specific. The issue of, let's see, 177, the boarding / commercial arena requirement for a CUP. As it goes to the issue of operating a facility like that. And again, I understand that you disagree with the code interpretation, but getting a CUP would have allowed these uses on the property, right?
Well, I can only speculate, but that 177 isn't about use on the property. It's about advertising an event offsite. So I'm not aware of any ordinance that restricts that in the first place, let alone a conditional use permit you would need to get a variance from an ordinance that doesn't exist in the first place. They haven't articulated, I mean, here today they said that they're unsure, is it a commercial riding arena, equine training facility? My previous understanding, the only thing they eventually took issue with was whether it was an equine training facility and whether riding having lessons on site was a violation of the ordinance. And that is something subject to the CUP, but that's not what she was cited for. She's not doing that activity. She's cited for advertising an off-site event. So I don't believe it's fair to characterize this issue as something Ms. McGuire could have or ought to have avoided by following through with the CUP process. Okay.
Moving real quickly to 178 to do with the RVs. And I understand the issue with the skirting and how the original violation was closed out based on that. But are there RVs that are being rented out on the property?
No. No, Ms. McGuire.
You want me to answer? No.
So I do note that in the code section for RVs, they are not allowed to be used as rentals as the final provision for that.
Yes, and even though both, let's see, the original citation, 526 from November 2022, that says several occupied and skirted RVs in use, possible RV park in operation. Okay, well, they satisfied themselves that that wasn't the case. The citation at issue that Ms. McGuire is appealing, the only charge there is property owners have a skirted RV on the property. RVs cannot be used as permanent residence, an RV cannot be skirted. So there's no, the prior RV wasn't used as a residence, period. And we're going to discuss here today that the skirting, which isn't defined in the ordinance, but the county's explanation to Ms. McGuire made sense. Something has to have an R value. I mean, we're trying to prevent people from having a non-conforming ADU on their property, in essence. So, you know, skirting with an RV value tends to lend to the belief that that's what's going on. Just a barrier to keep out animals doesn't. So, you know, this is a clear example of where that Ada County case comes into play. I mean, if there's, we don't know what, the ordinance doesn't define skirting. And if there's more than one reasonable interpretation, the law compels the interpretation that favors the free use of the property by the property owner. Which we shouldn't even have to get there, frankly, because that's the conclusion the county has already reached. Yet, they somehow changed their mind, which I guess is their prerogative, but we'll just revert to their prior interpretation of the ordinance.
All right, I may have more questions for you in the future, but thanks for letting me interrupt. Please
Yes.
proceed.
Yes, thank you, sir. So, Ms. McGuire, and is there a particular, should I call them up, or can I ask them questions from?
Well, I suppose, is that mic hot?
It is now.
Okay, so, that should work, if you want to ask her some questions and she
Okay.
can.
Yes, thank you, Ms. McGuire. And let me just focus on the RV issue first. You were cited in November of 2022 in case 526. And about a week later, Mr. Sepulveda came out to the house. Is that correct?
Correct.
And tell me what his conclusions were as he communicated them to you.
We walked around, looked at the RVs, talked about the RVs. They were winterized. He looked at the vinyl snap-on barrier that I had. We talked about that. He touched it, handled it, said there was no RV factors, that it was there strictly to keep dogs and rodents out from under the vehicle, the RVs. And everything else was fine. There were only 2 RVs on the property.
And those RVs, they weren't permanent residences.
No, actually, my RV was winterized and not even being used at that time.
And so did Mr. Sepulveda tell you whether he would continue and try to enforce the code violation? As he
No, he
understood?
said everything was clear.
Everything was clear,
Correct.
and you're certain of that?
Yes.
Okay, and then you noticed that for some reason the violation hadn't been released in around April or so,
Correct.
and you went in and they eventually released the citation, to your
Yes, I made a
knowledge?
phone call.
Okay. And then had anything changed from the time Mr. Sepulveda came out to your property in November of 2022 and the date of the second citation in June of 2023 with respect to your use of the RVs?
No, nothing had changed.
Did you add any insulated skirting?
No,
Did you have any people renting the RVs?
no.
Did you receive any money for those RVs being on your property?
I had, I used the one as an Airbnb, and which Mr., I can't say his last name, I'm gonna call him George, told me that that was adequate. I could use it as long as it was temporary and not a permanent resident in there. And they had an address somewhere else. And Ben Tarbutton also told me the same thing, as
Okay.
long as they had a permanent resident somewhere else.
Was that occurring in June 15th of 2023?
No, that was back on the first violation that we had that conversation.
Yeah. No, but your use of the RV on the second violation.
Oh, I was getting ready to use it as the Airbnb because I only use it during the summer months.
Was it being used as an Airbnb when you were cited? In June of 15?
I would have to pull up my app and see if I had any residents in there on June 15th, but I don't know exactly if there was somebody from Airbnb in there.
Okay. And what exactly did Mr. Sepulveda tell you with respect to Airbnbs? I know you kind of explained it previously, but,
we were talking about continued income for me, and they said that there was no problem using them as temporary intermittent use, as long as whoever was in it had a permanent resident somewhere else, and they were just there temporary.
And in describing, you said to provide some cash flow. Is that because you were no longer doing?
Correct, because I was not doing any outside horse activity at that time.
Okay, and that remains true today?
Correct.
Okay. So that kind of gets us to the second citation at issue here. We have this flyer that, let me just pull it up here. And this is Exhibit F, this flyer. Do you recognize that?
Yes, I do.
Okay. And it says there's a kids' camp on June 21st, 2023.
Correct.
Was there any event on your property on that date?
No,
Okay, so this was an off-site event.
correct.
Okay. And you noticed Mr. Sepulveda parked at the entrance of your property on that date, correct?
Correct, conversing with my neighbor.
And then you took a photograph of Mr. Sepulveda at the entrance of your property that date, correct?
Correct.
And that is this is included in the packet, does that look like that
Yes, it
photograph?
is.
Okay. So that's all I have for Ms. McGuire. I have one other witness I'd like to call briefly.
Okay, I have a quick question for Ms. McGuire. Again, regarding the CUP that looks like you applied for at the end of 2022.
Correct.
What happened with that? Did you withdraw that application? Did you pay for that application?
I started the process, and in conversations I had had with George and Ben Tarbutton, with my former attorney, there were some questions that were supposed to be answered that Mr. Tarbutton was going to get me some answers back about the leasing situation. And George was working on some investigation that he said would conclude, and he would give us the conclusions of that before we proceeded forward. April, I never heard of from anyone, so I had called George. And he said, well, he was waiting on Ben. So I called Ben, and Ben said, well, we're not doing anything. We haven't even started it yet. Talk to George. So I called George back, and I said, oh, nobody can tell me what's going on. And not long after that, I got the notices that both the violations had been released.
Thank you.
Thank you. And then Ms. Danielle Smith.
Just want to sit here.
All right, please state your name. And so, is this an affected party, or this is you're calling a fact witness, let's say?
Fact witness.
Okay. Okay, please proceed. Please state your name and address for the record, please.
Danielle Smith, 1711 Spruce Street, Sandpoint.
All right.
All right, thank you, Ms. Smith. First, is it true that you board a couple of horses at Ms. McGuire's property?
Yes.
And were you boarding those horses in November of 2022?
Yes.
And do you regularly go to the property to check on those horses?
Yes.
Were you aware of the condition of Ms. McGuire's property with respect to the RVs on site in November of 2022?
Yes.
Were they being used as rentals for permanent residents?
No.
Was there anyone residing in them permanently?
No.
Was there any skirting that was used for insulation that you noticed?
No, the skirting has been the same throughout the whole time I've been there.
Okay, and that's to present?
Yes.
So you were there in June of 2023 when Ms. McGuire was cited for the skirting a second time?
Yes.
Okay, and was there anyone residing in the RVs at that time?
No.
Okay, and how do you know?
I know this because the 2 horses that I board are in a pasture directly behind those RVs. So I see those RVs on a daily basis, and nothing has changed. And nor has anybody been living in those RVs. I would know. I'm there multiple times a week.
Okay, and then kind of moving forward to the second notice of violation concerning this flyer promoting a kids camp off-site. Were you on Ms. McGuire's property June 21st, 2023?
Yes, I was.
And how do you remember seeing Mr. Sepulveda parked at the entrance of the house?
Yes, I was, and that's one of the reasons why I'm here today, is because I was present with my horses at the time and saw a car with a seal on it who was on the other side of the property looking through someone else's property onto hers, and I felt quite alarmed. I had my children with me. I didn't know who it was, and it was very uncomfortable. So that is one of the reasons why I'm here in support today.
And is that why that date sticks out in your memory?
Yeah.
Okay. And you then, did you ride or did you care for your horses that day?
Yes.
Okay. Did you observe any,
I observed him talking to the neighbor and pointing into the property.
was there a kids riding camp held on the property that day?
No.
Okay. Thank you. That's all I have.
Yep.
Unless, sir, you have any.
And just real quick, the flyer doesn't state a location at all, right?
That's correct. That is correct. It does have a picture. And Ms. Smith, is this Ms. McGuire's property?
No.
And that's all I have for this witness.
Okay. Thank you.
Am I good to go?
So with that, I'll wait to hear what the county has to say, unless you have any questions, sir.
I think that's it for now. I do reserve the right to ask you questions later, of course.
Yes.
But let me just check real quick. We did just get another couple potential in favors. I'm not sure if they are falling under our definition of affected parties, though, to fall into our next portion of the procedure, which would be affected parties who could testify under a 5-minute. Just real quick, based on what I said before, it looks like it's that same address. I don't think the 3 of you are neighboring property owners. Is that correct? Not neighboring property owners? Okay, so from these 3 sign-up sheets and that response, I'm determining that you're not affected parties to be able to testify for this next portion of the procedure. So we'll move on to the county then.
Okay, thank you, sir.
All right, Mr. Callahan, are you in charge of the county's presentation?
Yes, sir,
All
and
right.
thank you. First, a few housekeeping measures before I move into the details of things. In your packet, it's rather voluminous. The first 5 pages are the staff report that I wrote. Following that are another 6 through 55 pages that are the original appeal. I included that because it had exhibits A through G. And so to try and make it easier to understand, I'll be curious to hear if it worked. I marked all of that as Exhibit 1 and then listed the following exhibits from the county numerically as 2, 3, 4, and so on, to try and separate out that we have an appeal. Exhibit 1 has the exhibits in there that you've now seen, and we have our own exhibits. So I hope that was helpful.
Indeed.
And then also, there's a superfluous exhibit. It's the very last page of the staff report. I duplicated, that was my fault. It's called Exhibit 7. That's actually a repeat of what is Exhibit 5. So that was my error. I apologize. Otherwise, I think we're ready to move forward if you are.
Okay, I see what you mean now, yes.
Okay, thank
Gotcha.
you. This just gets you oriented on where this property is, north of 54. And at the southeast intersection of Howard and Caravel. It's in the rural zoning district. These were just informational items that George and Craig can speak to if it'll be useful at the moment. I think it's more important to move on to what we think is the real issue. And I will just say, to me, it's a complete red herring, if you will, to argue about the skirting. I have no issues whatsoever about skirting. I think that was cured when we closed that out. And then the second notice did, in fact, list all of the criteria you have read, of which there are 5 that anyone using an RV must abide by. My principal concern is that we have evidence that this has been, the RV, has been used as a rental, which is a direct violation of code. And to my knowledge, it does not have a PhD septic permit, which is also a violation of code. Those are my principal concerns about the RV. It's comforting to hear that apparently it's no longer being used. I hope that continues to be the case, but my understanding is that it has been used. There's evidence in the file I'll get to in a moment that people have attested to online saying they used the RV as a rental, and that's improper and illegal.
So, and just, I'm gonna stop you there just
Yes, sir.
to address it while we're here.
Yes.
I did try to look into code if there were provisions about vacation rentals versus, rentals in general. And I could really only find vacation rental mentioned twice in the code in the commercial zones, talking about what can happen in the commercial zones. How does the county handle short-term rentals and or define them?
Thank you for bringing that up, because it's important to know we do not regulate Airbnbs in any way. A person may use their home as an Airbnb or another legally permitted residence on the property if, for instance, it's possible to have an accessory dwelling, which it can be in some zoning districts. That can be used as an Airbnb. The starting point here is very different. And I take issue with that notion that my staff would say that it's okay to use an RV as an Airbnb because they know that it's a rental of an RV is impermissible, as it has been stated in the staff report and is on the screen at the moment. This is the evidence in your packet that attests to the RV having been used as a rental. And when you look at this exhibit, you'll see that there are 6 people that have responded to it, saying that they were actually there using it as a rental. So that was one of the reasons that gave me grave concern, especially insofar as we know this still has no Panhandle Health District septic permit. So that's a health concern. I want to go back to what to me is a bit of a red herring with the skirting, but also the statement in the appellant's appeal that the staff is driven by malice or at least has reckless disregard. I believe that's not only inaccurate, but a misconstrual of the actual facts. both of the staff that do this code enforcement are here, and I'd like to bring them to the lectern in a few minutes so they can give you their experience with this. But my experience is that the staff takes requests from neighbors or complaints from neighbors, I mean, and then we research the case to find out if there's a conflict with code or not. Here we found two conflicts, the RV and the riding arena. And so I don't believe that it's at all an issue that the staff is being punitive in any way. We're handling this in the usual customary procedure. As I mentioned earlier, there are exhibits 2, 3, 4, 5, and 6 in the packet. 2 is the RV, 3, 4, 5, and 6 get to the riding arena use. And I would just like, I know you've read this, but I want for the audience's sake just to highlight how the code defines a commercial riding arena, and it is. A commercial riding arena or equine training center or facility is a building or part thereof dedicated to clinics, workshops, and training of horses. An equine training center or facility may include boarding stables. So that's the starting point. The reason for me reading that into the record is that you see on the screen exhibits 3, 4, 5, and 6, which give us cause for concern that the property is being used as a commercial riding arena. Where it gets a little gray to me is events that are occurring off-site. Nonetheless, I'd like the staff to respond because my understanding is that even though parts of that riding arena event may occur on other properties or even in a state park, in my view, it's impermissible to use the property even to congregate and collect fees and then send people off to a different property, because that meets the definition of the facility I just read into the record for you, I believe. In particular, it's in looking at the applicant's own information, the appellant, the information that they put on the internet, they say we offer lessons, boarding, training, overnight haul-ins, mare care, stud standing, and so on. And we have an outdoor arena, a round pen, and an indoor arena. That, to me, walks and quacks like the duck of a riding arena definition that I read for you. So with that, I would like to ask Craig and George to step in and just give you their experience with this case, because I believe it would be useful.
Well, let me stop you real quick. I do have a couple questions in that regard before we move on.
Yes, sir.
I guess more in a general sense, I kind of want to understand how you guys have treated these facilities in the past, because I will say I do see a bit of a discrepancy in the code. Because there also is a definition for boarding stable, which seems to be a bit at odds with this and a bit of an overlap. And as the appellant has pointed out, there's some provisions that kind of make some excuses for if it's just a boarding stable. So I'm having a hard time, including
Understood.
within the code, distinguishing between the two, because it seemed to be nearly the same thing by
get it.
definition.
I understand perfectly, because part of the problem is it's hard to write code to address every issue. But what the code says is that it is permissible to have boarding under certain defined circumstances. It just also goes on to say that boarding may be part of a riding arena equestrian center. So going back to your earlier questions to the appellant, if we were to process a CUP, we could get all of these things out on the table, know exactly what's going on, where and when. A boarding facility could be permissible as part of the CUP.
All right, thank you. You may proceed.
Thank you. Craig, would you lead off, and then pull in George to the extent you think it's useful?
Sure. Good afternoon, Mr. Hearing Examiner. Craig Davidson, Supervisor for the Code Enforcement Division here in Kootenai County. A couple things of clarity I would like to offer up. Ms. McGuire's attorney referred to these as citations. They are merely notices. They're not citations, just as a housekeeping item. We don't issue citations with fines. We only issue notices of violation or courtesies notices with fees assessed. And I'd like to go to the initial contact that George had with them. The original case that was submitted for, our cases are normally written complaints. We don't go actively searching issues or violations within the county. We have certified complaints signed, emailed, or on our online system with IMS. So George did get a complaint back in 2022. It was on about November 15th of 2022. Opened up a case for, we got a signed complaint for our occupied RV use with several occupied and skirted RVs. George noted the violation. And this is, I believe, I'd probably have to defer to him, his contact with Julie. And in that one, he did definitely look into it and found that there was no violation at that time, as she and her attorney indicated. We closed the case out. The next time that we were notified, again, we opened up a case on a separate noted circumstance or occasion. And I'll just let George talk to that for the chronology of it.
Just real quick for your name for the record.
Yes, sir. I'm George Sepulveda, Code Enforcement Officer 2 with Kootenai County. Get my eyes on. Yes, sir. On the second instance where we did receive a complaint on the occupied skirted RV, also RV being used as a rental, we did issue a notice. During that time, we had documentation or the ad showing that the appellant was using the RV as an Airbnb rental, which is obviously against county code. During my first contact with Ms. McGuire, I did talk to her and we did verify that there was only 2 RVs on the property. The skirting was just a barrier to keep animals and pests out. I advised her that yes, that is allowable by code so long as it's not being used as a primary residence, and that she can continue to use it as a temporary and intermittent use. I never advised her that it's okay to be used as a rental. I would never and have never said that. Yeah, the only other thing as part of my investigation, I was getting constant information from neighbors that there was events transpiring on the date of the 6/21 when the kids' event was apparently transpiring. I did go to the location just to verify whether it was or was not happening. I posted at the end of the block with permission from the property owner where I was at. It was across the street from the LaPan residence. I was not on the public road or the private roadway, and I wasn't on Ms. McGuire's property. During that time, I did see a kid on a horse exit the property with 2 escorted females, and they walked out, and that's all I can attest that I saw on that day. I couldn't see onto the property any further than from my location, so I can't say that there was more going on within the property.
How long were you there?
I was there approximately an hour.
And you didn't see other people coming and going?
I did not see anyone else after I left. Obviously, after I left, I didn't see anyone. During that time, I was there a little early, just to get in position, if you will, so I can get a good vantage point. During that time, I did see Miss McGuire drove up to me in her side-by-side, and she was asking who I was. I identified myself. She recognized me after I did so. Yeah, she videotaped me, took some pictures of me, and then kind of left in a bit of a hurry on her side-by-side.
Okay, so you just said, going back just real quick, you were receiving complaints from neighboring property owners about events taking place on the property?
Correct.
Was it specifically about the flyer, that event that the complaints were for, or was it for other?
It was other events as well. All the information I have was provided to me by the neighbors on the property.
Okay. So, so then why in your citation, did you just refer to, that event? That, the flyer, the Facebook flyer?
That's the only one I personally saw someone leaving the property. That was the only one I can personally attest to. I saw a child of approximately, I would say 10 years old, leave the property on horseback being escorted by 2 females. That's why I only did that one.
Okay, can you just elaborate a little bit on your procedure for how you do those and how you fill in that block of what the citation is for? Or not, again, sorry, not citation,
Notice.
notice.
Normally, everything like Craig said, normally everything starts with a written complaint. Once we get that complaint, we will go investigate it as best we can. Obviously, we do try to get some kind of dialogue going with property owners so they can explain to us what's going on, if anything. So during that second one with the writing event, I was advised that it was going on that day, if I can come out, and I did so.
Okay, and then, so just to be extra clear here, so you're not gonna include in your notice what someone reported, you're only gonna include what you were able to
What I was able-
observe or gather from an investigation?
Correct. What I personally see and what I find.
And if I may interject, Mr. Hearing Examiner, we generally cite that specific part of the code and what the operational aspect is applicable to the code for the violation, so they know what they're doing. And the remediation steps or corrective steps needed to take care of it for future use.
Okay, and again, the notice, just, I won't put words in your mouth, what's the purpose and kind of sequence of events? What's the purpose of a notice primarily?
Number one, generally, if it's an initial notice, a courtesy notice, if it's not a life safety thing, we send it out. It's the dialogue communication. This was reported, this is our findings, and here's some corrective actions you need to take. Please call us. And then we work the details with them from that point on. Secondary to that, a notice of violation would be issued if we get no communication, because as, in general, code enforcement, we will not enter private property without permission of a property owner. So many times in the rural areas, we get as far as we can to see, and that's our only method of communication is that initial notice. Then that's when we get the dialogue started and say, look, explain what you're doing. We'll be glad to come out and entertain a site inspection. We can work through some things, talk to some things. If there's some discrepancies you feel, we address them at the time. And then we document that, say, okay, these are the corrections you need to make. And we'll refer to an agency if it's outside or one of our internal divisions to help for planning for conditional use permits or additional permitting requirements in case of building or other issues.
Okay. So, and real quick, and I hate to have to go look through this file again, but there was an original, looks like notice that had to do with the horse issue. We'll just say there's the RV and there's the horses. How was that one resolved?
The initial one, that was the contact that they spoke of in 2022. So got the notice, got the complaint, got the notice. It's the 15th. I can go back to the dates and look at it for you, but it's the 15th. And then actually, that's the one I believe that you did the onsite with Julie.
Correct.
And She explained what's going on. He took a look at it and said, okay, you're good according to code for the RV issue at that time.
And then an initial application for.
Conditional use
For a
permit.
conditional use permit was filed after that. Did that factor into releasing that or closing out that file? Is there a difference between, like, when you close out a notice, what does that mean?
Well, the issue with the RV, the initial one in 2022, that was a simplified response that we just had to investigate. She was compliant with. We closed it out. If it's something that requires additional permitting, like a land use issue, like a conditional use permit, special notice permit or something like that, we'll work with the property owner for a period of time, make sure it's in submission, and it goes through the process to either be denied or approved. And then at that point in time, we dismiss it. So those can be timely. Obviously, building permits can take several months. Conditional use permits, because of timing, public notice and stuff, can take 6 to 9 months.
So did you decide to close that out because there was a pending conditional use permit, or why else?
The initial conditional use permit requirement notice that was sent out was closed out. Eventually, when I spoke to Ms. McGuire, she stated that, and she had already spoken to our planning department, which advised her that the only thing allowed without a conditional use permit was the boarding of horses. Once I met with her, I advised her that yes, you are allowed to board horses, that can be your source of income. She asked if she can sell hay to her boarders. I said, I believe that would be allowable to sell hay to the horses that she's boarding. After that, we did have a phone interview. I don't know if it was this one, I believe it was, when Ben, myself, Mr. Oler, and Julie had a phone conversation, and she did bring up the fact that, she was not going to be doing any more lessons or any events. We did, I remember Ben Tarbutton distinctly say that care leases would be considered a non-allowable act, because in a sense, she's just renting her horse to let someone ride it, and that would be similar to, it's basically a lesson. If she rents one of her horses to an individual for an hour and has one of her persons there as a safety person, I think it's semantics right there with just providing a lesson.
All right, let me just, I suppose, Mr. Callahan, that's all the questions I have right now, but the ball's still in your court, Mr. Callahan.
CUP 22-0022 still remains on the books as well, in process. One of our planners sent back a correction notice of requirements needed to proceed further, should they choose to do that. There has been no official cancellation of that application as of this date.
Okay.
Anything else?
No, that's it.
Okay, thank you. Mr. Hearing Examiner, I neglected to point out earlier that we did receive a total of 8, or I think it was 9 responses to our referral notice. I say I think it was 9 because I know there were 5 in support and 3 opposed. One of them didn't check the box of whether they were opposed or in favor. So I think there were 9 total. One, we don't know what they think.
Okay.
And I would just like to clarify next time we're going to start putting page numbers on these big dockets, but on physical page 38, which was part of the appellant's appeal, they've copied in our attorney's response, which to me makes it unambiguous that a CUP is required for a riding arena. So I don't think that much is contested. The real argument is whether this use rises to a level of a riding arena. We think it does, for the reasons I've already described and the evidence seduced. And with that, I believe we will stop unless you have questions.
Yeah, I guess maybe I just want to real quick expound on that, and thanks for everyone's patience, but, just because it is a little bit of an odd sequence of events of how we got here, rather than this being, say, a challenge to a code interpretation, right? So they ask you, let's interpret what we're proposing to do on this property, and you tell us if this is this or that within our code. And so, and thanks for just letting me think out loud for a second. It seems like that is kind of one of the nuts of what's at issue here, is the county's interpretation of your own code about whether these uses are, should be considered a commercial riding arena, boarding stables, or equine training facility, I guess I should say. And it's the county's determination that, maybe how would you draw the line there?
I'll defer to Craig, but first let me just state there's a couple of things that come to mind. One is I think it's rather telling that we never actually got what's required as part of a CUP, which is a written description of what you just suggested, all of the uses. That was one of the things Amy Hillen said was missing as part of a complete application. So that's part of the reason why this case is somewhat fuzzy, if you'll pardon the term, because we don't know exactly what's going on. We know what neighbors have told us. We know what little we've been able to observe from adjoining properties. But it's always hard when there's not a public road right next to something and we don't have forthcoming property owners, to be blunt. Craig wants to tag on to that.
Yes, and typically, many times, in fairness to applicants, they really don't know the scope of what they're doing until they get in there and work with the planner, and they get more descriptive, and they drill down to what they really need. The project description for this CUP submitted by the applicant in this case, again, I'm referring to CUP 22-0022, said this is for a riding/boarding facility located in Athol, Idaho. We are looking to be able to do lessons, workshops for people of all ages, host clinics, as well as provide boarding and training of horses. And again, that's a general statement when applicants come in, but that is the specific statement given to us for this CUP.
Which again argues that it's a riding arena, in my view.
Okay.
Thank you.
All right, I think that's all the questions I have right
Thank
now.
you.
Again, reserving the right to
Of course.
ask any more at the end, but understanding that the appellant will have the last word. But we do have an opportunity now for affected parties who wish to speak in opposition. Real quick, let me just double check that. Yeah, so I'm getting our affected parties language back up here. We do have a couple people who signed up who are opposed and therefore potentially affected parties. I do see some addresses on Caravel Road. I'm gonna, but they say do not wish to speak. I will just say, it does say does not wish to speak for Steve McCormick, Helen McCormick, and Brian Saputsky. Is that still true that you do not wish to speak?
I would like to say, I'm Helen McCormick.
Oh, well, if you do want to speak, as a potentially, affected party here, please come up to the microphone, identify yourself and your address.
Okay, I'm Helen McCormick. I live right across the street from Julie, 31833 North Caravel Road, Athol, Idaho. And I want to address the event. I mean, I don't know about that particular event, but we had 100 cars go down our street when she had an event for Halloween, petting the ponies in costumes. And I felt that was really violating our area as far as fire. We had a lot of fires going on at that time, and nobody could have even gotten out. That's what I got to say.
Okay, thank you, ma'am. And the other two gentlemen I just read, now would be your opportunity to speak as a potentially affected party. All right, but then I do also have one other who only listed a PO box. Tony, I'm sorry, I can't read the last name, Junior. Lathan Junior, who is opposed and may wish to speak. Are you an affected party, as I described earlier?
Next to Julie for 5 years, I just moved.
Okay, okay. At this point, if you have moved, do you no longer own the property?
I don't own the property, but I do have information that also impacted us while we lived there.
I think given the definition of affected party, you're probably no longer a directly affected person.
I would like to clarify one thing by her attorney. It
I-
was my property and the neighbors that George was parked on.
I'm sorry, sir, but we can't allow you to have outside testimony. I'm sorry, it's county code. We're only allowed to have affected parties give testimony. I apologize for that, but
Can I ask a question?
is-
Let somebody from Sandpoint talk.
that was a fact witness as part of the,
He's a fact witness.
I have video, I have pictures, I have whatever you want. You already got them, I can give it to you again.
that would be the prerogative of the county to call you as a fact witness. I don't have that authority. That would be up to the county if they want to use you as a witness to present testimony as part of their case.
Oh, can I just say one more thing? Okay, come up there.
Okay.
Yeah, I also wanted to address.
Please
Wait
till you-
till you get to the microphone, please.
Helen McCormick, the event situation, there has been, I've been there for 17 years, 2005, maybe it's 18. But it was every week. Every Wednesday, it was date night, and right there on her party, she'd have on her property, right across the street from me, there was like jumpy castles and people parked all over, and, it wasn't just that particular thing that she, that they were talking about. That was maybe one day. We're talking about years especially 2 years of constant weekly events. Every week. And every Wednesday, and then loud music on the weekends when they'd have, music and, campfires and all that. It wasn't horrible people, I'm not saying that, but it was like, we're on a dead-end road. And the road is getting beat up. Our road is, we take care of our own road, and she's not paying extra for it. So, I don't know. Don't believe it was just one event. It was years.
To your knowledge, when was the last time that there was an event on the property?
The event that I'm talking about was, there was weekly events all the way till 22, all the way through 22. November, that Halloween one was 100 cars. I had a video, I probably could get it. Again, I'd have to probably, have somebody help me. But, I took a picture of vehicles, 100 cars, and they're taking money down here, cars, her daughter, I don't know how much they charged, but, I'm sure it was a booming business, but, that really isn't what us neighbors wanted to be objected to at all, constant. We're talking, this was daily, her daily horse rides, her daily, she had a guy that was a professional speaker that would come into the arena and talk to people, advertise that. She knows what she was doing, yeah.
But to your knowledge, the last time you saw kind of an event like that was in November 2022?
Yeah,
Okay.
yeah, that I can recall. Yeah, because after that, the police came down and everything.
All right.
So we've been dealing with that.
Thank you very much. All right. If the county has nothing else, I'm going to kick it back to the applicant or the appellant. Sorry.
There's a Chris Spellman online on Zoom.
Okay.
I don't know if he or she wants to speak on Zoom.
Okay.
Chris, if there's anything you want to say at this time, please unmute yourself and go ahead.
Yeah, I would like that. So I'm Chris Spellman. I am a direct affected neighbor because I am directly next door to Julie. I have observed all these events for the past, almost 2 years now. And she has them all the time. George just came out to my property and observed a bunch of, Julie and her events as well. She claims she's not having them still, but yet we still have trailers coming down our road nonstop. We have people nonstop. We have been in verbal arguments on the road about it. And she, of course, wants to say, no, there's nothing going on. But really, we all know the reality of it. There's still events going on. The trailers out back are still skirted. They're still there. She still has people living in them. I have had people attest to that she rented out the trailer. She rented out the front house to her mom. So this is all still happening. She is just trying to find ways out of it. But like with this hay sale thing too, we still have a 40-foot trailer coming down the road daily, 3-4 times a day with hay. And to my knowledge, that's not just selling hay to your borders. If you're bringing that much hay down the road every day, that is selling it, in more extreme. And I had to actually physically call the cops on her multiple times over people riding on my property, the fact that her horses just, they let their feces go wherever they want to, and it's on my property. And then I was one that called the cops the first time on the report of the Halloween event when that happened, where she had hundreds of cars down the road, and the fire marshal actually got involved on that one because they couldn't get down the road.
All right. Can you tell me your address for the record, please?
31658 North Caravel Road.
Thank you. Is there anything else, or is that the end of your testimony?
So that would be basically the end of my testimony. And I also, hold on, one more part of that. So I'm also on the HOA as vice president, and so I can speak for the road as well at the meeting we had, where the meeting actually had a conversation about this, because she does have all this traffic down the road. She does have these events still happening, and there's plenty of members of the homeowners association that would like to see a stop to this, and they learned at that meeting that they could put in the formal complaints with the county on how to go about this. So there will be more complaints being involved in this, and hopefully we can get this resolved.
Okay, and I'm sorry, real quick, you just testified that you are, you see, you just said skirting on the trailers, and you see people inhabiting the RVs?
Yes.
And how recently?
The last time that I walked back there physically and saw it was about a month ago. I can walk to the back of my property and see exactly over to where these skirted RVs are. Julie actually had a surveyor come out and do property lines, so I actually still need to move my fence. But when I still walk on my property over to where my property line is now, I'm about 15 feet, 20 feet probably off the closest trailer that she has back there. And you can't get that trailer out, because to get that trailer out, you would have to go onto my property or onto the back property owner's property to get it out. There's just no other way to get that trailer out now, because it's been there so long, skirted and inhabited.
All right, thank you. I have no more questions for you.
Thank you.
Thank you for noticing that, Mr. Callahan.
There's no one else on Zoom at this time, so I believe we're done.
All right, that means the final act tonight will be the appellant's rebuttal.
Yes, thank you, hearing officer. There's been quite a lot of noise here today, so I'll try to just dispel it and be as brief as I can. One thing I'll point out, it's interesting that Ms. McCormick, who speaks out against Ms. McGuire here tonight, testifies the last time she noticed a big activity on the property was in November 2022. Well, this whole brouhaha with the county arose when Ms. McGuire had this gal named Dana at her property. And in the record, I included correspondence between Mr. Sepulveda and Ms. Dana to identify how they were in kind of constant communication. Dana's gone. That whole issue is resolved. Mr. Davidson said it best when he asked, well, what is the purpose? You asked, well, what do you try to put in your notice of violation? He said, well, you cite the code, and then you try to find, and then he said, quote, what operative aspect? The description of the violation is what operative aspect was violated of that code. That provides notice. And if you look at the citation, let's talk about the RV citation at issue. It says RV, property owners have a skirted RV on the property. That's the only affirmative statement. Then it just says RVs cannot be used as a permanent residence and cannot be skirted. Doesn't say anything about rent. Doesn't say anything that you are renting the RV, you are using the RV as a permanent residence. The only thing it says is you are skirting the RV. And I had no idea they were going to take the position they took here tonight. I can only go off what their notice says, just as a property owner. Just as a property owner. It is unfair to sandbag a property owner by providing them notice that makes them think, oh, this is about one thing, and then raising another issue at the time of an appeal hearing. So, but there's also, they just misquote the code. I mean, the staff states that this is a public health hazard because there's no Panhandle Health District approved septic, and makes the representation to this hearing officer that that is what the code says. That is one element that can satisfy that subpart of 8.4.401. The other is, or shall be totally self-contained. Like most RVs, it has its own self-contained system that is permissible under the code. They write that, they read that clause as if it doesn't exist based upon the argument you've heard here today. So this comes down to notice. And the skirting, I think, is Mr. Sepulveda has stated, I'm sorry, I'm mispronouncing that last name.
Sepulveda.
Sepulveda.
Yes.
Sepulveda, thank you. Mr. Sepulveda has mentioned no one cared about the skirting, and that's great. That's, walking into this room today, I was not under that impression. As, again, the only thing the notice said affirmatively, i.e. what you've done wrong, is you have a skirted RV on the property. So, they seem to argue now, this is coming out in this hearing, their basis for the violation is renting the RV. Okay, and if they could put up Exhibit 2, Mr. Callahan.
That'll take a few minutes, because I closed it out.
Did you receive a copy of the staff report?
I did not. Okay, Exhibit 2. So this appears to be, as of September 15, 2023, this is their evidence. You had this RV, you were renting it. Well, Cheyenne and Ms. McGuire are going to testify that RV was not on their property on that date. And was that correct, Cheyenne?
That is my RV.
Is that your RV?
Yes.
Was it on Ms. McGuire's property on September 15th, 2023?
I'm sorry, I was looking at the screen. You need to identify
Oh, sorry.
yourself for the record, please.
Oh, sorry.
Come over to the, okay, that's fine. Right there.
I'm Cheyenne Brisson.
Legally, I still am.
Sorry, I just got married. I'm Cheyenne Brisson. The picture in Exhibit 2 of the RV is my RV, and it was not located on that property any part of September.
And then is that consistent with your recollection as well, Ms. McGuire?
This is true.
When was it on the property?
You can't.
It was there from, we went camping with it 4th of July weekend, and then I was getting ready to move, and so I asked her if I could park it on her property for a couple of months. And then we took it back off of the property. So we parked it there mid-July. And we took it back off the property the last weekend in August, because we were settled into our new place and that's where it's been.
Thank you, that's all I have. Thank you, sir. So this, again, coming into this hearing, I did not know this was going to be the basis for their violation. There it is, Exhibit 2. The person who owns the trailer has testified that wasn't even on the property at the time of that citation. Or, sorry, notice of violation. And there's no evidence of any other violation in the record, given that they concede the skirting is not skirting as defined under the code, or as they interpret the code. So that gets me to this, the CUP. And the hearing examiner had asked earlier, certain questions about the CUP process or Ms. McGuire's application. And I have not been involved with that process, but I deal with advising clients on variables and costs that they can control. And I did tell Ms. McGuire, particularly after she had 2 citations for things that were demonstrably false, that, it's probably not worth they have it out for you. You're not going to get it doesn't matter what you seek a permit for. You may get it, but based on their past conduct as any guide, they're probably going to fight you. So that's the reality that people face when they decide to deal with the county. If the county is citing them for violations they themselves have admitted they shouldn't cite them for, and there's a repeated ongoing pattern of that conduct costing money, and Ms. McGuire, like most people, does not have unlimited resources, you have to do the cost-benefit analysis. And is it worth it? So to the extent that the county believes that Ms. McGuire's conduct is self-inflicted because she didn't obtain a CUP is not relevant to the notices of violation. And going back to the notice of violation in 177, that's the advertised off-site event. Now, they mention in their presentation, well, we think this is a commercial riding arena, and we think this is a equine training facility. Well, the only thing that happened between the original citation in June of 2022 and the citation in June of 2023 was Ms. McGuire got rid of Dana, who did the event in November of 2022 on Halloween. And at the time Dana was there were a significant number of boarders. There were more activities. Dana left Ms. McGuire's relationship and her property under terms that were not favorable, as evidenced by the document I submitted where she was communicating with the code enforcement. But again, we're here on a violation that was issued in June of 2023. We're not looking backward at what had occurred. And going back to the notice of violation, you look at it and it says, property owners are advertising a kids' riding event without the required CUP. That is all it says. It doesn't say, hey, you have a commercial riding arena, or hey, you're doing equine training activities. It doesn't say that. Had it said that, those would have been addressed. And she wasn't warned. She wasn't warned for these the notices of violation in June of 2023. As Mr. Davidson said, it would have been great had the county said, hey, we notice you're, and it would have saved people, everyone here today, a lot of time potentially, if they had said, hey, we noticed there's this flyer for a kids' riding camp. We need to discuss this. Are you doing that on your property? And she would have said, no. Okay. No violation. With respect to the RV, has anything changed? No. No violation. They didn't do that. They just went straight for issuing these notices of violation. And now, we've got, as a staff, they have interpreted this, again, without receipt of the staff report, I don't know exactly what's before you, but based on what I hear here today, and as the staff said, their interpretation of the code is now, if you have an off-site event, but people congregate on your property before going to that off-site event, that's a violation of the code. That's appears to be what their true basis of this violation is. They concede the event that didn't occur on site. And the only evidence they have of a congregation, assuming everything they say is true, is what the code enforcement testified to, where he watched two people leave the property on that particular date, implying that two people had congregated on Miss McGuire's property. And the act of congregating in and of itself converts property into either a commercial riding arena or a equine training facility. And that's simply not in the code. We all can have our own subjective interpretations of what a particular statute or code or ordinance might mean. But when you are dealing with and disenfranchising someone's free use of land, Idaho law is clear. If Ms. McGuire's interpretation is reasonable and the statute or ordinance isn't clear, her interpretation controls. That's the end of the analysis. That's black letter law. So, pointing back to this statute, this ordinance, my apologies, 8.5.111. No real definition of commercial riding arena, what that is, other than something that can hold at least 50 people, which there's no evidence that her pole barn can do that. Equine training facility, what does that mean? Does that mean, I read that, my first reaction when I read this code was that's, oh, you're training horses. People bring their horses and you train them and you break them. I don't see equine training as giving lessons to kids. But again, we're not here because they're not presenting evidence that there were lessons being conducted. Their evidence is, we know you advertised an event and we believe, based on witnessing two vehicles leave your property that morning, there was congregation on your property. And under our interpretation of the code, that is something for which you would need a conditional use permit. Well, I believe that's a stretch, but we have, Ms. McGuire has another interpretation. That is, there is no ordinance that prevents you from advertising an event that doesn't occur on your property. There is no ordinance that prevents people from meeting and congregating on your property for the purposes of not doing anything prohibited under the code. And then there is what I think is plain language under 8511 subpart I, quote, boarding stables which are not associated with a commercial riding arena or equine training facility shall not be required to obtain a CUP. That was Ms. McGuire's interpretation. It's mine. The notices of violation are vague, ambiguous. The county is arguing for violations of portions of the statutes or ordinances cited which aren't on the face of the notice of violation themselves. And again, both of these violations at issue were preceded by two other violations that the Board of County Commissioners, or the county had dismissed and essentially gave a mea culpa. Yet here we are again. Thank you. Mr. Callahan, could you turn to Exhibit 3?
3?
3?
Well, I will when I can get the computer to work.
That's good.
That would be it in the center, horseback adventures.
Oh, yes. Is there a way?
So
Is that
I would like
sufficient for
to
you?
talk about all of these, actually.
Well, just very briefly.
Yes,
It's only
very
it's
briefly.
something that they raised.
Yes.
Okay. Exhibit 3. Is this okay, Mr. Hearing Examiner?
Yes.
I would like to clarify a few things, and I'm going to approach up here because I'm blind.
Is that okay?
Yeah, it's okay. Please bring the microphone with you.
Certainly. Okay, this is the said RV that I was cited for. First of all, it's not skirted. Second of all, it didn't come to the position it's in until after the Moye mud bogs on 4th of July. And it got cleaned up and brought to here. Okay, I'm assuming I can't read all of
But
it.
you advertised it as an Airbnb rental, correct?
The month and a half it was at my property, I did advertise it as an Airbnb because I was told I could Airbnb temporary use my RV.
Okay.
So I was there, I just looked up on my Airbnb, I had 6 people in it from July 28th to September 5th. 6 people, 1 night, maybe 2 nights, and that's it. Okay, this was an off-site event, didn't happen on my property. George knew it didn't happen on my property because he was there. Okay, this event that you guys are using to prove that I have events on my property, this was a 4-H event up at Sandpoint Fairgrounds. They called us and asked us if we'd bring our mini ponies up because they didn't have any for their, I want to say fitting and showing, for their judging competition. And so they asked me if I could bring some minis up because I've been a 4-H leader for decades. So I hauled these minis up and we showed them for the kids to judge for 4-H. Did not take place on my property again. So therefore, I do not need a conditional use permit to travel to Sandpoint to do a 4-H favor. Okay, this is one of our camps we had, and it's not on my property. This is a boarding ad. You brought up that I advertise on here for lessons and training and all of that. Yes, prior years I have, and I admit that, and yes, when Dana was on my property, that was happening. After I got my Facebook page back from Dana, I went in and I changed everything because I have no intentions of doing lessons, clinics, or anything else on my property. So this is all stopped since Dana left. There have been no events on my property or anything else. The event that Chris, my neighbor who spies on me through the woods, who's about 150 feet from the RVs, what he saw in, actually it was October, was my daughter and her new husband the night of their wedding in that RV. Not that RV, but my RV, because that one was at their house. Or no, that was behind the barn. And so I just want to clarify that these accusations that are being made, just because you see somebody go in an RV doesn't mean they're living there. It means my daughter spent 2 nights at my house after her wedding on my property. Anything else, the big events that all these neighbors talked about? Yep, they happened. Yep, did I converse with George? Yes. Did I try to get it straightened out? Absolutely. I came to a dead stop on my conditional use permit because I still have not heard back from the county on their takes of the questions we asked when I was in there on a phone conversation with George and Ben Tarbutton, and it was not Nathan, it was David Keys on that phone conversation that I had with them that I'm still waiting for answers from. So I have not pursued my conditional use permit. I also have been told all kinds of wild stories about this conditional use permit and the county and all this stuff and the road committee that continues to harass me, even though none of these things are happening at my property. I board and that is it.
Thank you.
And,
Anything else, Counselor?
well, I will say, I had not met Mr. Sepulveda prior to today. So he mentioned that he had a meeting with me. It wasn't me. So, you know, I think if you look at the changing narrative, the lack of the who, what, when, and where, and just a scattergun, vague, ambiguous approach where they're citing things that aren't even on, that's in Bonner County. Had I known that, I would argue, are they interpreting the code so that you can't advertise an event that requires, you know, an activity in a neighboring county? Thank you, that's all I have.
All right. Thank you. And as I do believe, according to the code and as a proper matter of procedure, appellant should have the last word. So that is going to be the end of, and I have no more questions for you. So that is going to be the end of tonight's hearing. 7:41, I'm going to close out the public hearing for APP 23-0001. Thank you all for your time and patience. Have a good night.